John Scopes was charged with the crime of teaching human evolution in a classroom in Tennessee. A few weeks before he was charged with this crime, the legislature in Tennessee had passed a statute known as the Butler Act that made it a crime for any teacher in a school supported in whole or in part by state funds from teaching that any theory that denied the story of the divine creation of man as taught in the Bible, and to teach instead that man has descended from a lower order of animals. Now, John Scopes had only taught biology briefly in the classroom. He agreed to be indicted, to serve as a test case challenging the constitutionality of the statute. He was convicted. The judge imposed a fine of $100 and went up on appeal on various grounds, and the Tennessee Supreme Court overturned it, and on a single technicality that the judge had imposed the fine, not the jury, and then dismissed the case because Scopes no longer was employed as a school teacher, and said that should bring an end to this bizarre case. And the case itself, this story that we'll talk about today, wouldn't be but a mere footnote in American history, except for one thing. That was Darrow's cross-examination of William Jennings Bryan. Bryan was a prosecutor in the case. Darrow was the defense attorney defending Scopes, and he called Bryan as a witness in the case. So I want to explain to you how that came about. It was an amazing turn of events. And the cross-examination itself is just a remarkable document to read. In the handout, I tried to annotate a version of the cross-examination. But first of all, I want to talk a little bit about the statute that Scopes was tried with violating, because the interpretation of it determined the course of the trial. And let me start by doing a little audience survey. I'll ask for a show of hands. I want you to study this language and tell me if you think it was enough that the prosecution just proved that Scopes had taught that man descended from a lower order of animals. If that would have been enough to convict him. Or if it was necessary for the prosecution to prove also that he had taught a theory that denied the story of the divine creation of man as taught in the Bible. So raise your hand if you would, if you think it was enough that the prosecution just proved that second clause. Okay. How many of you think it was necessary for the prosecution to prove both clauses? Well, the judge was against all of them. So I asked Brian Garner, who is the editor-in-chief of the Black's Law Dictionary, he's a friend of mine. I asked him how he would, he's a textualist. And he wrote a book with the late Scalia on textualism, which is the idea that statutes, constitutions, should be interpreted just based on the language of the statute constitution, not based on also outside sources like legislative history or according to the policy goals of the drafters of the statute. So I asked Brian as a textualist what he thought of the interpretation of the statute. And I had in mind in particular a provision of his treatise that he wrote with Justice Scalia, which he says that stands for the proposition that the word and creates a conjunctive prohibition. And whether he believed then that it was necessary for the prosecution to prove both of these, or if the word instead made it disjunctive. And here's Brian's answer. Wowza. I think the canon, that is that the conjunctive and require the proof of both, probably applies, but instead makes it an arguable point. And I think it's on a knife's edge. But Darrow was smart to argue that both events were proof, that both events of proof were necessary. Now, the judge was himself a fundamentalist, somebody who believed in literal interpretation of the Bible. And the prosecution really had no evidence that Scopes had taught any theory that denied the story of the divine creation of man as taught in the Bible. They only had evidence that he had taught the theory of human evolution. Their evidence were the school superintendent and two students who testified that yes, Scopes had taught this. They offered no evidence really of what the divine creation story was, except they offered as one exhibit a King James version of the Bible. So perhaps you could read into that and maybe read the one interpretation that Brian believed was necessary to hold that as proof that Scopes had violated that too. But the judge said there's no need to prove both. You only had to prove that Scopes had violated by teaching human evolution. So from that point on, the trial became quite easy for the prosecution and quite difficult for the defense, because the defense had lined up lots of experts, theological experts and science experts, who were going to testify, the theological experts who were going to testify that they were Christians and they had their own interpretation of Genesis and the divine creation story. And under their interpretation, they didn't believe that the world was created in 6 literal days, but yet they believed in Christianity. And the science experts were all going to testify about the scientific basis for evolution and human evolution in particular. And the judge's interpretation of the statute had rendered all of those experts and their testimony irrelevant, because it wasn't necessary to prove what the divine creation story was. It was only necessary to prove that Scopes had taught human evolution. Now, a version of this statute was passed a couple of years after Tennessee passed it by Arkansas. And Arkansas was a little smarter than Tennessee. They eliminated the first clause. And they only said it would be illegal in Arkansas to teach that man had descended from a lower order of animals. Because, and Justice Ford, that statute was eventually ruled unconstitutional by the US Supreme Court in 1968 as a violation of the Establishment Clause. And Justice Fortas, in that decision, said Arkansas probably eliminated that first clause from its statute because the first clause showed more clearly what the motivation of the legislature was. The motivation was to prevent a teacher from teaching a theory that would undermine a certain biblical belief. That is a literal interpretation of Genesis. So if you eliminate the first clause, you're sort of disguising, covering your tracks on what the motivation for the statute was. And Brian believed that human evolution was part of what was known then as theistic evolution or creationism evolution. It was more of a wishy-washy version of Christianity. And he thought it was going to lead to the end of Christianity itself if people didn't believe in the literal interpretation of Genesis. Because here's how it went in his mind. There had to be a moment where 2 people, Adam and Eve, were created. And at that moment, they were infused with a soul. And shortly after that, they had disobeyed God and committed a sin that every human thereafter would bear. And that all of humanity then needed to be expiated of those sins by Christ dying on the cross. And if you believed in all this, then you would have something and eternal life. This was Brian's belief of Christianity. And it didn't hold up, this doctrinal chain of events in Brian's mind, if instead Homo sapiens evolved over many years from some group of hominins, not just two people created in a moment, but scores of Homo sapiens had evolved. At what point were they infused with a soul? At what point did one or all of them commit some original sin? The theory of Christianity that Brian relied on just wouldn't hold up if the theory of human evolution was taught in the classroom. So that's what Brian was upset about, was the teaching of what he called a theistic evolution. I had a quote from Brian marked in my book where he said in the speech against Darrow that this theistic evolution lulls Christians to sleep. It's an anesthetic which deadens pain while religion is being removed. So how did it come about then that Brian was cross-examined by Darrow? Because the experts weren't allowed as evidence to testify as evidence of the unconstitutionality of the statutes. So the judge allowed the defense to offer the defense testimony as an offer of proof. So the jury wasn't going to hear it. An offer of proof is when you make a record of what you would have put before the fact finder had your evidence been allowed in by the judge. And when the judge doesn't allow it in, you instead make an offer of proof for the record. So the appellate court can see what you would have offered as evidence. So the judge allowed them to make an offer of proof, all of these experts, and what they're going to testify to. And they were going to offer the experts live, put them on the stand, and get direct testimony from each of them on theological grounds for their belief in Christianity, scientific grounds for evolution. And the prosecution said, well, we want to cross-examine them. And this was rather bizarre. It's not unheard of that an offer of proof, live testimony could be subject to cross-examination, but it's not evidence. It's an offer of proof. So it's generally unheard of that a judge would allow the prosecution to cross-examine a witness as merely an offer of proof. But I think that the judge allowed it. He said, if you want to put this witness on the stand as offer of proof, then the prosecution gets to cross-examine. And I think the judge just couldn't bear the idea that experts could testify for hour after hour. And his point of view, the prosecution's point of view, would never get an airing. If he granted the prosecution the right to cross-examine these witnesses that they took the stand. And Darrow and his team decided to not put them on live. One of his co-counsel, Arthur Garfield Hayes, later said, we did that because we were worried that the prosecution would ask the scientists if they believed in the miracles of the Bible. And they would deny that they did, that they did not believe in miracles and supernatural events. So to avoid that, instead, they prepared written statements from all of the experts. And Hayes then proceeded to read these into the record. And it took several hours where he read into the record the theological experts, the scientific experts, and everything that they would have testified to. And you might imagine how this made Brian feel sitting there, listening to all these statements of theologians who did not agree with the view of Christianity, experts, academics, extraordinary credentials, saying why the theory of human evolution is true. It must have been hard for him to bear. And then the trial proceedings were then moved outside by the judge. The courtroom was so jammed with people that the judge was worried, the maintenance people in the building were worried that the floor was going to collapse. So they moved the proceedings out into a deck, or a wooden stand next to the courthouse. And that's where Hayes continued to read these statements. And in the background, there's a picture of this in the background, there was a giant banner on the wall of the courthouse that said, "Read your Bible." And Darrow never asked that to be taken down while Hayes was reading these statements. And I think this was deliberate. But when Hayes was finished reading the statements, then Darrow and his co-counsel moved the judge to remove that banner. And this created something, of course, on the prosecution. And Brian said, "Well, if it bothers them so much, I'm not opposed to it." So Brian had to sit there, waiting and probably watching while somebody took down the banner that was really the motto of his life. Read your life. And you can imagine how much of an effect this would have had on Brian. After listening to all these expert statements, and then having to watch this banner taking down from the courthouse wall. It was at that point that Hayes called Brian to the witness stand. And this was a bit of a surprise. A bit of a surprise to everyone. But Brian almost immediately agreed to take the stand. And they called him to the stand with a further offer of proof. This would be live testimony now, because Brian held himself out as an expert on the Bible. So they were going to cross-examine him as an expert on the Bible. His fellow prosecutors objected vigorously. This is outrageous. You would call your opposing counsel as a witness. But Brian, he said this outright. He did not want to be seen as afraid to answer their questions. So he took the witness stand. And Darrow was cross-examined. And he proceeded to basically play that William Jennings Bryan. He didn't start with the story of creation. He didn't ask Brian outright, do you believe the 6 days of creation was in 24 hours? Instead, he started running through some of the miracles of the Bible. They're testing Brian's confidence that these things had happened. Did Jonah live in the belly of a whale for 3 days and then get spit out? Did Joshua command the sun to stand still so that the daylight could be lengthened and the battle that was fighting could succeed with the longer day? Did Brian believe that all the languages of the world were just created some 4,000 years ago when God confounded the languages of the people of Babel because they had been building this house, rightfully and arrogantly, from their city? And Brian pretty much stuck all of these things as being true, these supernatural events. He told Darrow in frustration at one point, I can believe one miracle just as easy as any other. So initially, Darrow had Brian agreeing that he literally believed everything in the Bible, everything, and then history. But then Darrow got around to the story of creation. And here's where Brian sort of veered out of literal. And he took the position that a day in the 6 days wasn't necessarily 24 hours. That it could have been 10,000 years. It could have been 100,000 years. It could have been 60 million years. And that's what Darrow wanted from him. That was the object of the cross-examination. If he could, to get Brian to admit that the Bible was subject to interpretation. Because if the Bible is subject to interpretation, then somebody could teach that man had descended from the lower of animals and not be violating the prohibition that they deny the story of the divine creation of pain. And I think the way in which Darrow asked these questions of Brian, I'm just going to have to fun with Brian here. I was going to read a little bit of this exchange, but I'm going to let Brian. I'm going to let Brian play the role of Darrow. I'll be Brian. Yeah, let's see. We're going to start with Joshua's story. Yeah. I want to show you how Darrow extracted from Brian an admission that the Bible was subject to interpretation. Now that on the story of Joshua making his sons do. So go ahead, Ryan. Help you, Brian.
You believe Joshua made the sun stand still?
I believe what the Bible says. I suppose you mean that the earth stood still.
I don't know. I am talking about the Bible.
I accept the Bible absolutely.
The Bible says Joshua commanded the sun to stand still for the purpose of lengthening the day, doesn't it? And you believe it?
I do.
Do you believe at the time the entire sun went around the earth?
No, I believe that the earth goes around the sun.
Do you believe that the men who wrote it thought that the day could be lengthened or that the sun could be stopped?
I don't know what they thought.
You don't know?
I think they wrote the fact without expressing their own thoughts.
Have you an opinion as to whoever wrote the book, I believe it is Joshua, the book of Joshua, thought the sun went around the earth or not?
Believe that he was inspired.
Can you answer my question?
When you let me finish the statement,
It is a simple question, but finish.
you cannot measure the length of my answer by the length of your question.
No, except that the answer be longer.
I believe that the Bible is inspired. By the way, did a very generous judge here, Brian did, who let him give statements as answers instead of just answering yes or no, or I don't know. I believe that the Bible is inspired, an inspired author, whether one who wrote as he was directed to write, understood the things he was writing about, I don't know.
Whoever inspired it, do you think whoever inspired it believed that the sun went around the earth?
I believe it was inspired by the Almighty, and he may have used language that could be understood at that time.
Was
Instead of using language that could not be understood until Darrow was done.
so it might not. It might have been subject to construction, might it not?
It might have been used in language that could be understood then.
That means it is subject to construction?
That's your construction. I'm answering your question.
Is that correct?
That is my answer to it. By construction is another word for interpretation. It's subject to interpretation.
Let's go over to 29. Is it your opinion that passage was subject to construction?
Well, I think anybody can put his own construction upon it. But I do not mean that necessarily that is a correct construction. I've answered the question. There he's gotten Brian to basically admit that was all subject to an interpretation. Let's see that on 6A.
This is on page 62. Where she came from, you do not know. All right. Does the statement, the morning and the evening were the first day, and the morning and the evening were the second day, mean anything to you?
I do not think it necessarily means a 24-hour day.
You do not?
No.
What do you consider it to be?
Well, there's two of them. Let's see. Again, he's allowed to answer. Let's get the next question.
Okay. Then, when the Bible said, for instance, and God called the firmament heaven, and the evening and the morning were the second day, that does not necessarily mean 24 hours?
I do not think it necessarily does.
Do you think it does or does not?
I know a great many think so.
What do you think?
I do not think it does.
You think those were not literal days?
I do not think they were 24-hour days.
What do you think about it?
That's my opinion. I do not know that my opinion is better on that subject than those who think it does.
You do not think that?
No, but I think it would be just as easy for the kind of God we believe in to make the earth in 6 days, or in 6 years, or in 6 million years, or in 600 million years. Do not think it important whether we believe one or the other.
I think those were literal days.
My impression is they were periods. But I would not attempt to argue as against anybody who wanted to believe in literal days.
Have you any idea of the length of the periods?
No, I don't. There, he got Brian to admit that it was all subject to interpretation. And Alan Dershowitz, professor at Harvard Law School, wrote the introduction for the latest edition of Darrow's autobiography. And he referred to these two parts of the transcript, to the Joshua, the son story, and the days of Genesis, as evidence that Brian had got the better of Darrow. He says that Brian had showed he was not some know-nothing literalist. And for the most part, he had actually seemed to have gotten the better of Clarence Darrow in the argument. And that Darrow had obviously expected Brian to claim that the sun orbited the earth, as the Bible implies. But Brian disappointed him by testifying that the earth goes around the sun. I don't think, Dershowitz and I have read the same transcript. I don't think that Darrow expected or cared what answer Brian gave him. If Brian had said it's 6 24-hour days, he would have had Brian looking like a fool. That the earth was only 6,000 years old and was created in 6 24-hour days. If Brian acknowledged that a day could have meant, as he did, 6 million years or 600 million years, well, then it's subject to interpretation. Darrow was following that rule of cross-examination that you never ask your witness a question unless you know the answer, or unless you don't care what the answer was. And I don't think Darrow cared, because either way, he won. Either way, Brian looked like a fool, or he looked like someone who was willing to acknowledge that the Bible was subject to interpretation. But what Darrow did in the end was make Brian look like a fool. Like, not just ignorant, but worse. Somebody who was incurious. Someone who didn't wonder what history was or what the nature of human beings were. There was a part where Darrow had asked Brian something along these lines. And Brian had answered, "I have all the information I want to live by and to die by." Darrow, "And that's all you're interested in?" Answer, "I'm not looking for any more on religion." Question, "You don't care how old the earth is, how old man is, how long animals have been here?" Answer, "I'm not so much interested in that." Question, "You've never made any investigation to find out?" "No, sir, I have never." He made him to look like a fool. And Darrow was especially equipped to do this cross-examination. All of his life, he had been interested in science and had read many of the popular books on science. And I think, as Ryan mentioned, he had held in his apartment for many years what he called the Science Club, where his apartment was near the University of Chicago, where professor friends of his would gather into his apartment and talk about the latest books, not just on science, but literature and history, and psychology and poetry. He was interested in all of these subjects, steeped in them as much as any lawyer might be, and still be a lawyer. He was especially qualified, I think, to conduct this cross-examination. And it was the cross-examination that made this trial so famous as it is today. The cross-examination received headlines across the country, to the great embarrassment of Brian. And Brian died 5 days later. Now, in the movie Inherit the Wind, the Darrow character in the movie cross-examines the Brian character to death on the witness stand. And it didn't happen quite so dramatic. Brian stopped and said he believed that Brian had died of a cerebral hemorrhage. And it is possible that Darrow did contribute to his death. And after, well, it was in his autobiography, Darrow said that he had felt a little sorry for what he'd done to Brian. But then he remembered that Brian had been traveling the country, giving these anti-evolution speeches, tormenting teachers and school administrators, trying to get them to remove from their curriculum any teaching of evolution, to get biology teachers who taught this fired. And he comforted himself in that he may have contributed to Brian's death. Remember what Brian did all those years. So we have a few minutes left for questions. I'd be happy to try to answer them. Anybody has any questions? Or I could tell the story how I found these letters that started the collection. Yeah.
So to bring us up to today, we have threats of pulling funding for teaching certain things. So was there any of that in this era? Was there any threats to funding any schools that would allow teaching such as this, or was it only in the criminal law?
It was in criminal statutes mostly. I think they'd use the funding tactic in the statutes. You might think, why is this case of such importance? Because it didn't create a precedent really that these statutes were unconstitutional. In fact, he upheld the statute. I think what the scope trial stands for today is the idea that we should challenge authority sometime, particularly when the authority is this nasty combination of government and religion teamed up together to prevent people from learning or from teaching or from researching, investigating things. I think that's the why this case, this trial, the cross-examination is so symbolically important to us. Justice Fortas in the Epperson case, 1968, cited the Scopes trial as an embarrassment and a clear establishment of religion. Any other question? Yeah.
I have a two-part question. Professor, I think you mentioned that Scopes allowed himself to be indicted for violating the Butler Act. So my first part of the question is, was that for the purpose of bringing a constitutional challenge to the statute? And then the second, if so, and the second part of my question is, did these offers of proof, including this cross-examination, was that in service in any way of that constitutional strategy?
Yes, yes. Scopes had volunteered for the purpose of challenging the constitutionality of the statute, but it was only a challenge under Tennessee's Constitution. The U.S. Constitution, the Establishment Clause of our First Amendment in the U.S. Constitution, did not yet apply to the states through the 14th Amendment. That didn't happen until 1968. So all of Darrow's challenges were on the basis of the Tennessee Constitution, which had a similar Establishment Clause, which had some other language too that might have protected Scopes or been a basis for declaring the statute unconstitutional. But just that it all was staged in effect for this challenge to constitutionality. As I said, people like never got around to that. They found a way to put it in, as they said, to this bizarre case.
The no-go, sort of about how Scopes was noted. So the ACLU put out an ad and they said they would defend anybody who violated the act. And then there was some jockeying between different places on who was going to have the honor of getting the assault benefit. And it's both George Rapalea, who kind of there was a meeting at this place, Robinson's drugstore, And they all sort of agreed to do it. They were all friends, like the people who prosecuted Scopes knew it well and they were friends with them. So it was, yeah, it was just a tense case.
And Judge Walton was so eager to have the case. It was a chance to become a local celebrity. So, if I have a few minutes, I'll tell you how I found these letters. It was in 1991. I graduated from law school and I was working for a couple of years for a judge in Nebraska, Lincoln, Nebraska, and I knew no one. And I had in my head, I'm going to find a project, something to do in my spare time. And it occurred to me, I took a class from Joel Salma at the University of Minnesota, wonderful teacher, he passed away just a few months ago, on the history of criminal justice. And so I knew a little bit about Clarence Darrow, and I saw an ad for one of his clients' letters, Eugene Debs' letters that had just been published. And it occurred to me I'd never seen Clarence Darrow's letters published. So I contacted a couple of his biographers who were then still alive and asked them whether they thought this was a worthwhile project. And they didn't think it was, that there wouldn't be enough letters to make a book. But I started writing around to manuscript libraries, after asking, they would look in a collection of Theodore Dreiser, for example, at the University of Pennsylvania, or one collection or another, and send me copies of any Darrow letters that they had. I started getting back dozens of letters from these libraries. And I sent copies of them to Clarence Darrow's granddaughter, who were alive at the time, they lived in Wheaton, Illinois, near Honolulu. And they were delighted to get these copies, these letters. They knew their grandfather well. They were in their 20s when he died. And then one day I drove from Nebraska to Illinois to meet one of the granddaughters. And the day before, in anticipation of my coming, her husband had been down the basement rummaging around to see if they could find anything that I might like to see. And so when I arrived, they said, would you like to see a box that Gordon found in the basement? See a box that Gordon found. He brought it up, it was a garment box and large, and it was stuffed with letters written to Clarence Darrow by people like William Jennings Bryan, Woodrow Wilson, and Helen Keller, and H.L. Mencken, and Eugene Debs. It was just like a who's who of late 19th century, early 20th century America. So I suggested to Gordon we go back down the basement. And we did, and by the end of our digging, we found about 350 letters written by Darrow himself to his first wife and to his son, Paul, his only child, Paul. And scores of letters written by family members, Darrow's brother, his sister, and these scrapbooks that Darrow's first wife had kept of his early activities as a lawyer. Somebody many years before had squirreled these things away into the basement, and you would appreciate this. It was a dry, cool basement, perfectly preserving these documents all of these years. And Blanche and Gordon were so trusting of them. They let me take them all to Kinko's. I stayed up all night and I photocopied everything. I was so excited. And I called my friend Joel. He told me what I found, that I was, this was history discovery of a lifetime. That I knew now I had a book, something that was enough to make a book. All these personal letters. And personal letters are so revealing of someone's life. There's no better material for understanding a person, for a biography, really, than reading a lifetime of their mail. And then at the end of the night, I went back to Blanche and Gordon's house, and they made me breakfast, and I drove back to the press, and just floating. And then for the next 20-some years, I kept looking for Darrow's letters in the book. But Blanche and Mary wanted this collection to stay together. They didn't want it to be sold piecemeal to autograph collectors. Somebody who's just looking for a little piece of history. They want to stay together, integrity, to remain together so that scholars could study these letters and the papers, documents And they wanted to find an institution that would buy them and treasure them as they were treasuring them. And the University of Minnesota Law School, 2 miles from my office after all these years, acquired the collection through the San Francisco. So here the collection sits today, the beginning of a much larger collection that you have now, that you build on.
Well,